जो है हम डिस्कस करेंगे तुम्हारा जो CRVI का पेपर है, कॉर्पोरेट रिस्ट्रक्चरिंग इंसॉल्वेंसी लिक्विडेशन एंड वाइंडिंग अप, है ना, दिसंबर 2023 का ओल्ड सिलेबस का। ओके, तो चलिए चालू करते हैं। तो पहला है आपका क्वेश्चन नंबर 1A, ABC लिमिटेड इज प्लानिंग फॉर मर्जर विद RST लिमिटेड. As a CS, you have advised your management that all the shareholders of the transferor and transferee can give consent for the merger and thereby the shareholder meeting can be dispensed to save the time. However, CFO of your company has raised a doubt on your view. Hence, the matter was put up before a PCS who will advise on the matter to the company. So, as a PCS, referring the relevant provision and a case law, give your opinion on the matter. बताइए। सो क्या आंसर है? एज पर सेक्शन 230 सब सेक्शन 9 ऑफ द कंपनीज एक्ट 2013 जो NCLT है में डिस्पेंस करेगा विद कॉलिंग ऑफ द मीटिंग ऑफ द क्रेडिटर और क्लास ऑफ क्रेडिटर वेयर सच क्रेडिटर जो है क्लास ऑफ क्रेडिटर हैविंग एटलीस्ट 90% वैल्यू जो है एग्री एंड कन्फर्म बाय वे ऑफ एफिडेविट टू द स्कीम ऑफ कॉम्प्रोमाइज और अरेंजमेंट. सो इन द मैटर ऑफ स्कीम ऑफ अमलगामेशन हो गया बिटवीन जुपिटर एलॉयज एंड स्टील इंडिया लिमिटेड वर्सेस जुपिटर वेगॉन लिमिटेड. The question of whether जो ट्रिब्यूनल है can grant dispensation of shareholder meeting regarding proposed scheme of amalgamation in case में where all the shareholder have given consent and Companies Act provide only for dispensation of the meeting of the creditor having 90% value agreed and जो है confirmed by way of affidavit was led before the court. तो जो दो मेंबर हैं ऑनरेबल NCLT कोलकाता बेंच हेल्ड that the word may जो है provided in section 230 subsection 9 में of the Companies Act 2013 introduces an element or essence of discretion and thus vest in the NCLT में inherent power to dispense with the meeting of the member and or creditor. So finally जो bench है noting that NCLT has inherent power under rule 11 में of the NCLT rules 2016 read with rule 24 sub rule 2 of the company's rule 2016 car rules compromise arrangement amalgamation allowed dispensation of the meeting of the shareholder whilst observing the following. So it cannot be ignored that almost all the high court जो have exercised this discretion को since long and dispensed with the calling of the meeting in appropriate situations में. So the precedents created by the high court to dispense with the requirement of convening the meeting are worth and continuation of such precedents are virtue in the era of ease of doing business as well as future course of corporate actions. तो ये settled जो issue है should not be unsettled without proper reasons. Thus the notion that calling of meetings is mandatory does not stand. So based on the above mentioned case law, where all the shareholders have given their consent and post merger there shall be positive net worth and the creditors are not compromised, it is advised to the management to get the written consent of all the shareholders of the transferor and transferee so that the requirement of the shareholder meeting can be dispensed with. Okay. So next question है due diligence is an important exercise है for any potential investment proposal. So discuss करो importance of due diligence for a proposed merger. Also enumerate करो the types of due diligence को which may be taken for such a proposal. Okay. So क्या बोला गया है? जो ड्यू डिलीजेंस है इज एन इन्वेस्टिगेशन है और ऑडिट है ऑफ ए पोटेंशियल इन्वेस्टमेंट के बारे में. सो इट सिक्स टू कन्फर्म करेगा ऑल मटेरियल फैक्ट्स जो है इन रिगार्ड टू अ सेल. सो इट इज़ अ वे ऑफ प्रिवेंटिंग अननेसेसरी हार्म और हेल्सलीज टू आइदर पार्टी इन्वॉल्व इन ए ट्रांजेक्शन. सो इट रिफर्स टू इन्वेस्टिगेटिंग एफर्ट मेड टू गैदर ऑल द रिलेवेंट फैक्ट्स को एंड इन्फॉर्मेशन को दैट कैन इन्फ्लुएंस ए डिसीजन टू एंटर इनटू ए ट्रांजेक्शन और नॉट. तो जो ड्यू डिलीजेंस है इज ए मीनिंगफुल एनालिसिस है ऑफ द कलेक्टेड इन्फॉर्मेशन टू अराइव एट सम डिसीजन में अबाउट द पोटेंशियल ट्रांजेक्शन. जो ड्यू डिलीजेंस एक्सरसाइज है इज ए क्रूशियल टास्क है इन दिस प्रोसेस में जो फाइनेंशियल है जो नॉन फाइनेंशियल इन्फॉर्मेशन है ऑफ द टारगेट कंपनी का इज टू बी कलेक्ट किया जाएगा, एनालाइज्ड किया जाएगा इन ऑर्डर टू डिराइव प्रॉफिटेबिलिटी आफ्टर एक्वायरिंग द टारगेट कंपनी. So exercising due diligence is not a privilege but an unsaid duty है of every party to the transaction. So due diligence is integral to business and the same is exercised in all the transactions में whether a simple over the counter transaction or a complicated merger and acquisition transaction. So while acquiring a company, the buyer जो है must do thorough research of the credential of the company, its market valuation, status of account receivable, product and brand involved, position in the debt market में, status of legal and statutory compliances, past performance, etc. So it is also essential है to study the previous financial report को to analyze the company's performance, to check the company background, its promoter, general reputation and return to the existing shareholder. So different types of due diligence which can be undertaken for any proposed merger are as follows है. Financial due diligence. So the target company's financial performance is one of the most critical elements है, one must review. दूसरा है आपका लीगल ड्यू डिलीजेंस. लिटिगेशन इज वन ऑफ द मोस्ट एक्सपेंसिव रिस्क है ए कंपनी कैन अंडरटेक. So this makes the legal aspects one of the most critical types of due diligence in merger and acquisition में. So it helps to determine the risk level for these and other legal factors. तीसरा है operational due diligence. Operational due diligence examine the various aspects of the production and workflow. Then next है human resource due diligence. HR ड्यू डिलीजेंस जो एग्जामाइन करता है एम्प्लॉयमेंट एग्रीमेंट को, कंपनसेशन पैकेजेस, लेबर रिलेशन, सैलरी स्ट्रक्चर. देन नेक्स्ट है इंटेलेक्चुअल प्रॉपर्टी ड्यू डिलीजेंस. जो आईपी ड्यू डिलीजेंस है क्रूसियल है इफ द टारगेट कंपनी हैज यूनिक प्रोडक्ट और सर्विसेज दैट गिव इट ए कॉम्पिटिटिव एडवांटेज. देन नेक्स्ट है एनवायरमेंटल ड्यू डिलीजेंस. It helps to assess the target company's environmental impact and sustainability practices along with compliance with the environmental laws and regulations. Then IT environmental due diligence. IT environmental due diligence जो है crucial है for any company in today's digital world में. Okay. So next question है, one of the most important facets of the Indian merger control regime is the element of control है. Control over an enterprise जो है is the ability होती है to change the competitive dynamics of any market को. And the CCI जो है like all other competition regulator give due importance to changes in control. On this backdrop, elaborate on control and group under the Competition Act 2002 में and also through light on exemptions if any under this definitions में बताइए. So क्या बोला गया है, जो सेक्शन 5 है of the Competition Act 2002, control means the ability to exercise material influence, okay, in any manner में whatsoever over the management या फिर affairs के ऊपर या फिर strategic commercial decisions by one or more enterprises either jointly or singly over another enterprise के ऊपर और group, और one or more group हो गया either jointly or singly over another group और enterprise के ऊपर. Further जो group है means two or more enterprises where one enterprise जो है directly or indirectly in a position में होता है to exercise 26% or such higher percentage as may be prescribed of the voting rights in the other enterprise में, और अपॉइंट मोर देन 50% ऑफ द मेंबर्स ऑफ द बोर्ड ऑफ डायरेक्टर इन दी अदर एंटरप्राइज में, और कंट्रोल करेगा मैनेजमेंट को और अफेयर्स को ऑफ द अदर एंटरप्राइज का. सो डी मिनिमिस एग्जेम्पशन क्या है, द सेंट्रल गवर्नमेंट हैज ग्रांटेड एग्जेम्पशन टू द एक्विजिशन ऑफ अ स्मॉल टारगेट विच इज नोन एज डी मिनिमिस एग्जेम्पशन. कॉम्बिनेशन वेयर द एसेट्स और द टर्नओवर इज बिलो द स्पेसिफिक थ्रेशोल्ड्स नीड टू बी नोटिफाइड टू द कमीशन फॉर इट्स अप्रूवल के लिए. So according to the notification, all forms of combination involving asset of not more than 450 crore in India or turnover of not more than 1250 crore in India are exempted from section 5 of the act for a period of 5 years के लिए. Okay. So क्या बोला गया है, जो सेबी SST रेगुलेशन है 2011 का impose an obligation on the acquirer together with the person acting in concert to make public announcement of an open offer in the event of their becoming entitled to exercise 25% or more of the voting rights in the target company में. So what are the conditions under which the acquirer is exempted from making such open offer under regulation 10 sub regulation 1 clause A of the regulations में बताइए. So क्या बोला गया है इस पर, रेगुलेशन 10 सब रेगुलेशन 1 clause A of the SEBI SST रेगुलेशन 2011, following acquisitions shall be exempted है from the obligation to make open offer under regulation 3 में and regulation 4 में subject to the fulfillment of the condition stipulated therefore. क्या बोला गया है, acquisition pursuant to interstate transfer of shares among the qualifying persons being immediate relatives हो गया. person जो कि named as promoter in the shareholding pattern में filed by the target company in terms of the listing agreement or these regulations for not less than 3 years prior to the proposed acquisition. A company, its subsidiaries, its holding company, other subsidiaries of such holding company, persons holding not less than 50% of the equity share of such company, other companies in which such person holding not less than 50% of the equity share, and their subsidiaries subject to control over such qualifying person being exclusively held by the same person. Then persons acting in concert for not less than 3 years prior to the proposed acquisition and disclosed as such pursuant, okay, to the requirement under the listing regulations में, or as the case may be the listing agreement. The next बोला गया है शेयर होल्डर ऑफ ए टारगेट कंपनी who have been persons acting in concert for a period of not less than 3 years prior to the proposed acquisition and are disclosed as such pursuant to the requirement under the listing regulations में or as the case may be the listing agreement and any company in which the entire equity share is owned by such shareholder in the same proportion में as their holdings in the target company without any differential entitlement. सो नेक्स्ट क्या बोला गया है, प्रोवाइडेड दैट फॉर द पर्पज ऑफ अवेलिंग ऑफ द एग्जेम्पशंस अंडर दिस क्लॉज में इफ द शेयर जो है ऑफ द टारगेट कंपनी का फ्रीक्वेंटली ट्रेडेड है तो जो एक्विजिशन प्राइस है पर शेयर सेल नॉट बी हायर बाय मोर देन 20% ओके ऑफ द वॉल्यूम वेटेड एवरेज मार्केट प्राइस फॉर ए पीरियड ऑफ 60 ट्रेडिंग डेज प्रिसीडिंग द डेट ऑफ इशुएंस ऑफ द नोटिस फॉर द प्रपोज्ड इंटरसे ट्रांसफर अंडर सब रेगुलेशन 5 में as traded on the stock exchange में where the maximum जो volume of trading है in the shares में of the target company are recorded during such period में and if the shares of the target company are infrequently traded है तो जो acquisition price है shall not be higher by more than 25% of the price determined in terms of clause E of sub-regulation 2 of regulation 8 एंड जो ट्रांसफेरर है जो ट्रांसफेरी है सेल्फ कंप्लाइड विद द एप्लीकेबल डिस्क्लोजर रिक्वायरमेंट्स के साथ जैसे कि सेट आउट किया गया है चैप्टर 5 में. सो क्वेश्चन नंबर 2 में क्या बोला गया है, बेस्ड ऑन द फॉलोइंग इन्फॉर्मेशन फाइंड आउट द टोटल अमाउंट ऑफ परचेज कंसिडरेशन एंड द पोस्ट मर्जर कैपिटल स्ट्रक्चर ऑफ द कंपनी. कैपिटल स्ट्रक्चर जो है ट्रांसफेरर एंड ट्रांसफेरी कंपनी का एज फॉलोज है. तो ये प्रैक्टिकल है, इसको जो है अपन लास्ट में डिस्कस करेंगे. देन नेक्स्ट आते हैं हम हमारे नेक्स्ट क्वेश्चन की ओर. सो फॉर फंडिंग ऑफ रीस्ट्रक्चरिंग वेरियस फॉरेन करेंसी डिनोमिनेटेड इंस्ट्रूमेंट्स आर अवेलेबल है. So in this context, explain in brief the concept of depository receipts and eligibility conditions for issuance of the same. So क्या बोला गया है, depository receipt means a foreign currency denominated instrument है whether listed on an international exchange में or not, issued by the foreign depository in a permissible jurisdiction में on the back of permissible securities issued or transferred to that foreign depository and deposited with a domestic custodian के साथ. Here, permissible security means the equity, share and debt securities which are in dematerialized form and rank pari passu with the securities issued and listed on a recognized stock exchange में. So depository receipt जो है include GDR Global Depository Receipt as defined in section 2 clause 44 of the Companies Act 2013 as any instrument in the form of a depository receipt by whatever name called created by a foreign depository outside India में and authorized by a company making an issue of such depository receipts. A company may issue depository receipts provided it is eligible to do so in terms of the scheme and relevant provisions of the FEMA rules and regulations. So the rules relating to GDR are contained in the depository receipt scheme 2014. Okay, so eligibility क्या क्या है, the following persons are eligible to issue or transfer permissible securities to a foreign depository co for the purpose of issue of depository receipts. Any Indian company listed or unlisted, private or public, any other issuer of the permissible securities, any person holding the permissible securities which has not been specifically prohibited from accessing the capital market or dealing in the securities. Then next बोला गया है जो unsponsored depository receipts हैं on the back of listed permissible securities can be issued only if such depository receipts जो है give the holder the right to issue voting instructions and are listed on a international exchange में. So a company may issue depository receipts provided it is eligible to do so in terms of the scheme and relevant provisions of the FEMA rules and regulations. So next question है आपका, your company is considering for demerger of one of its division and requested you to prepare a note on amortization of the expenditure, carry forward and set off of the business losses and unabsorbed depreciation as per the provision of the Income Tax Act 1961. Okay, बताइए. So क्या बोला गया है, as per the Income Tax Act 1961, demerger in relation to company means the transfer हो गया pursuant to a scheme of arrangement under the Companies Act 2013 by a demerged company of its one or more undertaking to any resulting company को subject to condition specified. So the company before undertaking the demerger should consider the below mentioned provisions of the Income Tax Act 1961 with respect to the amortization of the expenditure and carry forward and set off of the business losses and unabsorbed depreciation respectively. The next है आपका amortization of the expenditure in case of amalgamation or demerger. So section 35 double D subclause 1 of the subsection 1 of the Income Tax Act 1961 provide that where an SSC जो है being an Indian company incur any expenditure wholly and exclusively for the purpose of demerger of an undertaking, तो जो SSC है shall be allowed a deduction of an amount equal to 1/5 of such expenditure for each of the 5 successive previous year beginning with the previous year in which the demerger take place. फर्दर जो एज पर सेक्शन 35 डी क्लॉज 2 है ना, सब सेक्शन 2 ऑफ इनकम टैक्स एक्ट 1961, नो डिडक्शन शैल बी अलाउड इन रेस्पेक्ट ऑफ द एक्सपेंडिचर मेंशन इन सब सेक्शन 1 में अंडर एनी अदर प्रोविजन में ऑफ दिस एक्ट के. सो कैरी फॉरवर्ड एंड सेट ऑफ बिजनेस लॉसेस एंड अनएब्जॉर्ब्ड डेप्रिसिएशन ऑफ द डीमर्ज्ड कंपनी में क्या बोला गया है. So section 72A clause 2 of the income tax act states that notwithstanding anything contained in subsection 1 में जो accumulated loss है shall not be set off or carry forward and जो unabsorbed depreciation है shall not be allowed in the assessment of the amalgamated company unless जो amalgamating company has been engaged in the business में in which the accumulated loss occurred or depreciation remain unabsorbed for 3 or more years के लिए, has held continuously as on the date of amalgamation at least 3/4 of the book value of the fixed asset held by it 2 years prior to the date of amalgamation. जो अमलगामेटेड कंपनी है वो होल्ड करेगा कंटिन्यूसली फॉर ए मिनिमम पीरियड ऑफ 5 ईयर्स के लिए फ्रॉम द डेट ऑफ अमलगामेशन एटलीस्ट 3/4 ऑफ द बुक वैल्यू ऑफ द फिक्स्ड एसेट ऑफ द अमलगामेटिंग कंपनी एक्वायर्ड इन ए स्कीम ऑफ अमलगामेशन में कंटिन्यूज द बिजनेस ऑफ द अमलगामेटिंग कंपनी फॉर ए मिनिमम पीरियड ऑफ 5 ईयर्स के लिए फ्रॉम द डेट ऑफ अमलगामेशन. देन तीसरा है फुलफिल करता है सच अदर कंडीशंस को एज में बी प्रिस्क्राइब टू एंश्योर द रिवाइवल ऑफ द बिजनेस ऑफ द अमलगामेटिंग कंपनी or to ensure that the amalgamation जो है is for genuine business purpose के लिए. So in a case where any of the conditions laid down in subsection 2 में are not complied with, तो जो set off of loss है या फिर allowance of depreciation हो गया made in the previous year में in the hands of amalgamated company shall be deemed to be the income माना जाएगा of the amalgamated company का, जो कि chargeable होगा to tax for the year के लिए in which such conditions are not complied with. Okay. So section 72A subsection 4 of the income tax act provide that notwithstanding anything contained in any other provisions में of this act in the case of a demerger में जो accumulated loss and the allowance for unabsorbed depreciation of the demerged company जो है shall where such loss on unabsorbed depreciation is directly relatable है to the undertaking transfer to the resulting company को be allowed किया जाएगा to be carried forward and set off in the hands में of the resulting company के. Where such loss or unabsorbed depreciation जो is not directly relatable to the undertaking transferred to the resulting company be a portion between the demerged company and the resulting company in the same proportion में in which the assets of the undertaking have been retained by the demerged company and transferred to the resulting company and be allowed to be carry forward and set off in the hands में of the demerged company के or the resulting company as the case may be. तो सेक्शन 72A सबसेक्शन 5 ऑफ द इनकम टैक्स एक्ट द सेंट्रल गवर्नमेंट मे फॉर द पर्पज ऑफ दिस एक्ट by notification in the official gazette specify such condition as it consider necessary to ensure that the demerger is for the genuine business purpose. So next question है आपका explain the provision relating to power of the CCI to impose penalty for the non submission of the information on combination. बताइए. So क्या बोला गया according to section 43A of the Competition Act 2002 if any person or enterprise fails to give notice to the CCI under subsection 2 में या फिर subsection 4 में of section 6 और contravene subsection 2A of section 6 और submit information pursuant to an inquiry under subsection 1 of section 20, तो जो CCI है वो impose करेगा on such person पे और enterprise पे penalty which may extend to 1% of the total turnover or assets or the value of transactions referred to in clause D of section 5 whichever is higher of such a combination. So it may be noted that in case any person or enterprise has given a notice under subsection 4 में of section 6 and such notice is found to be void ab initio under subsection 6 of subsection 6 में, then a notice under subsection 2 of section 6 may be given by the acquirer or parties to the combination as may be applicable within a period of 30 days of the order of the commission, okay, CCI under subsection 6 में of that section, and no action under this section shall be taken by the commission till the expiry of such period of 30 days. तो कितने ही सब सेक्शन और सेक्शन इसमें लिखे हुए हैं, कम से कम 100 वर्ड लिखा होगा सेक्शन और सब सेक्शन. So next question is, a PCS, a client has approached you and sought your guidance on the following procedural aspects of the fast track merger: declaration of solvency, filing of a scheme, approval of the scheme. So prepare a brief note on the aforesaid points to be presented to your client. बताइए. So as per section 233 of the Companies Act 2013 along with the Companies Rule 2016, compromise arrangement and amalgamation lay down the certain procedure for the fast track merger. तो ले डाउन किया गया है सर्टन प्रोसीजर को फॉर फास्ट ट्रैक मर्जर का इसमें. तो पहला है आपका डिक्लेरेशन ऑफ सॉल्वेंसी. ओके, क्वेश्चन के अकॉर्डिंग तो इसका प्रोसीजर क्या है? बोथ द कंपनीज जो है आर रिक्वायर्ड टू फाइल ए डिक्लेरेशन ऑफ सॉल्वेंसी विद द रेस्पेक्टिव एरिया ऑफ आरओसी के साथ वेयर द रजिस्टर्ड ऑफिस ऑफ द रेस्पेक्टिव कंपनीज आर सिचुएटेड. टाइमलाइन क्या है? दिस इज टू बी डन बिफोर द मीटिंग ऑफ द शेयर होल्डर और द मीटिंग ऑफ द क्रेडिटर इज कन्वेंट. ओके, तो मीटिंग जो होने वाली है उससे पहले ही जो है आपको फाइल करना है. कौन सा फॉर्म रिक्वायर्ड है? फॉर्म CAA10. हु विल बी रिक्वायर्ड टू कंप्लाई? बोथ द ट्रांसफेरर एंड द ट्रांसफेरी कंपनी आर रिक्वायर्ड टू कंप्लाई विद दिस प्रोविजंस के साथ. द नेक्स्ट है फाइलिंग ऑफ द स्कीम. प्रोसीजर क्या है? कॉपी ऑफ द स्कीम अलॉन्ग विद द रिपोर्ट ऑफ द रिजल्ट ऑफ ईच ऑफ द मीटिंग इन फॉर्म नंबर CAA11 shall be filed with the regional director के साथ. A copy of the scheme along with Form 11 is also required to be filed with the ROC in form number GNL1 and the official liquidator. So it shall be hand delivered or sent through speed post or registered post or official liquidator. The next बोला गया है timeline within 7 days after the conclusion of the meeting of the members or class of members or creditors. Then जो forms required है वो क्या है? Form CAA11 results of all the meetings, Form GNL1. ओके, देन नेक्स्ट है आपका हु सेल रिक्वायर्ड टू कंप्लाई. फाइलिंग विथ रेस्पेक्ट टू रीजनल डायरेक्टर इज रिक्वायर्ड टू बी डन बाय द ट्रांसफेरी कंपनी. ओके, देन अप्रूवल ऑफ द स्कीम बाय द रीजनल डायरेक्टर और द सेंट्रल गवर्नमेंट. सो वेयर नो ऑब्जेक्शन और सजेशन इज रिसीव्ड विद इन ए पीरियड ऑफ 30 days of receipt of the copy of the scheme under section 233 subsection 2 from the ROC and the official liquidator by the central government, and the central government is of the opinion that the scheme is in the public interest or in the interest of the creditor, it may within a period of 15 days after the expiry of the said 30 days issue a confirmation order of such a scheme of merger or amalgamation in form number card 12 में. If the central government जो है does not issue the confirmation order within a period of 60 days of the receipt of the scheme under section 233 subsection 2 में, it shall be deemed that it has no objection to the scheme and a confirmation order shall be issued accordingly. So where objections or suggestions are received within a period of 30 days of the receipt of the copy of the scheme under section 233 subsection 2 from the ROC or the official liquidator or both by the central government, and such objections, suggestions of the ROC or official liquidator are not sustainable, and the central government is of the opinion that the scheme is in the public interest or in the interest of the creditor, it may within a period of 30 days after the expiry of 30 days referred to above issue a confirmation order of such a scheme of merger or amalgamation in form number card 12. Okay, the central government is of the opinion, whether on the basis of such objection or such otherwise, that the scheme is not in the public interest or in the interest of the creditor, it may within 60 days of the receipt of the scheme file an application before the tribunal in form number card 13 stating the objections or opinion and requesting that tribunal may consider the scheme under section 232 of the act. So provided that if the central government does not issue a confirmation order under clause A or does not file an application under clause B within a period of 60 days of the receipt of the scheme under subsection 2 of section 233 of the act, it shall be deemed that it has no objection to the scheme and a confirmation order shall be issued accordingly. So जो confirmation order of the scheme का issued by the central government or the tribunal under section 233 subsection 7 of the act shall be filed within 30 days of the receipt of the order of confirmation in form number INC 28 along with the fees as provided under the Companies Rule 2014, registration office and fees with the ROC respectively. So next question है आपका practical problem है तो उसको हम last में करेंगे. ओके, then next आते हैं हम क्वेश्चन नंबर 3 clause A का. So you are one of the CS in the big multinational conglomerate which is contemplating a merger. So as the management is keen on completion of the merger without any regulatory hiccups, your departmental head have advised you to sound an informal consultation with the CCI suggests the management if such informal consultation is allowed. Brief the process of informal consultation with the CCI prior to the business combination and the conditions applicable if any. So in accordance with international best practices, जो CCI है allows for an informal and verbal consultation prior to filing of the notice to a proposed combination in terms of Regulation 5 of the CCI Regulations 2011 procedure in regard to the transaction of the business relating to combination. Read with Section 6 subsection 2 of the Competition Act 2002 with the Commission. So the parties intending to file a notice with the Commission are encouraged to approach the Commission for pre-filing consultation. So a request for pre-filing consultation should be made by the parties at the earliest and at least 10 days before the intended date of filing so that the Commission gets ample amount of time to allocate appropriate team expert in a particular case for pre-filing consultation. So a copy of the draft application comprising of Form 1, 2 as the case may be and supporting documents should be forwarded along with the request for scheduling a pre-filing consultation. So such जो pre-filing consultation है help the parties intending to file a notice with the Commission in identifying the information required for filing a complete and correct Form 1, 2, 3 along with identification of the additional information that the Commission may require to assess the likely impact of the proposed combination on competition in the relevant market में. Hence, it is apprised to the management that such informal consultation is allowed. Okay. So, a summary of the proposed जो combination है along with the following details should also be submitted. तो पहला है basic details of the proposed combination including various steps involved in the same, a brief description of the relevant market and sectors involved, the likely impact of the proposed combination on the competition in those market and sectors in general terms, key issues regarding which the parties wish to seek consultation from the Commission, any other details which according to the parties may be pertinent for a meaningful consultation. The next question है briefly discuss on earn-out and carve-out in the cross-border merger में बताइए. So an earn-out जो है is a contingent consideration है whereby the buyer of the target would decide an amount which is to be paid, okay, provided certain contingent consideration to happen, okay. जो क्रॉस बॉर्डर मर्जर है स्पेशली कवरिंग इंफॉर्मेशन टेक्नोलॉजी, टेक्नोलॉजिकल मर्जर, बैंकिंग मर्जर आर सब्जेक्ट टू कंटीजेंट कंसिडरेशन. अर्न आउट आर डिवाइडेड इनटू बिलो 3 टाइप्स में. कैश अर्न आउट है, इक्विटी अर्न आउट है, स्टॉक कंपनसेशन अर्न आउट है. सो एक कार्व आउट जो है इज ए पोटेंशियल डाइवेस्टीचर ऑफ ए बिजनेस यूनिट इन विच ए पेरेंट कंपनी सेल माइनॉरिटी इंटरेस्ट ऑफ ए चाइल्ड कंपनी टू आउटसाइड इन्वेस्टर्स को. सो ए कार्व आउट अलाउज ए कंपनी टू कैपिटलाइज ऑन ए बिजनेस सेगमेंट दैट मेनी not be a part of its core operations. So a carve-out effectively separate a subsidiary or business unit from its parent as a standalone company. So the new organization has its own board of director and financial statement. However, the parent company usually retain a controlling interest in the new company and offer strategic support and resources to help the business succeed. So unlike a spin-off, the parent company generally receive a cash inflow through a carve-out. Okay. So next question है discuss the provision for escrow account for open market buyback through stock exchange. So क्या आंसर है? Following are the provision है for escrow account for open market buyback through stock exchange. तो पहला बोला गया है the company shall within 2 working days of the public announcement as and by way of security for performance of its obligation under the regulation may deposit in an escrow account may such sum as specified as below. तो बोला गया है जो escrow amount है shall be payable in the following manner में. If the consideration payable है does not exceed rupees 100 crore or 25% of the consideration payable. If the consideration payable जो exceed rupees 100 crore or 25% up to 100 crore and 10% thereafter. जो escrow account है referred to in this regulation shall subject to appropriate margin as specified by the board consist of cash including bank deposit, okay, deposited with any scheduled commercial bank के साथ और bank guarantee issued in favor of the merchant banker by any scheduled commercial bank, deposit of frequently traded and freely transferable equity share or other freely transferable securities or government securities or units of the mutual fund invested in gilt funds and overnight schemes और ए कम्बिनेशन ऑफ दी अबव. सो एक्सप्लेनेशन में बोला गया है जो कैश कंपोनेंट है ऑफ द एस्क्रो अकाउंट में भी मेंटेन किया जाएगा इन एन इंटरेस्ट बियरिंग अकाउंट में provided that the merchant banker ensures that the funds are available at the time of making payment to the shareholders. नेक्स्ट बोला गया है where the escrow account consists of deposit with a scheduled commercial bank, the company shall while opening an account empower करेगा merchant banker को to instruct the bank to make payment the amount lying to the credit of the escrow account as provided in the regulations में. So where the escrow account consists of a bank guarantee, such bank guarantee shall be in favor of the merchant banker and shall be valid होगा until 30 working days after the expiry of buyback period or until the completion of all the obligation under these regulations may whichever is later. So the company shall, in case the escrow account consists of securities, empower the merchant banker to realize the value of such escrow account by sale or otherwise, and if there is any deficit on realization of the value of the securities, the merchant banker shall be liable to make good any such deficit. In case the escrow account consists of approved securities, there shall not be returned not by the merchant banker till the completion of all the obligations under the regulations में. Then where part of the escrow account is in the form other than cash है, तो जो कंपनी है shall deposit with a scheduled commercial bank के साथ in cash में a sum of not less than 2.5% of the total amount earmarked for buyback as specified in the resolution may of the board of director or the special resolution as the case may be as security for the fulfillment of its obligation under the regulations में. Then जो board है in the interest of the securities holder may in case of non-fulfillment of the obligation under the regulations by the company forfeit the escrow account either in full or in part में. So जो amount forfeit किया गया under clause J में may be distributed pro rata amongst the security holder who accepted the offer and balance if any shall be utilized for investor protection. So next question है QR Private Limited, a startup company, proposes for merger with the MN Private Limited, a small company. Explaining the meaning of the startup, brief whether the merger proposal can be carried out without the approval of the NCLT. If yes, name the authority with whom they have to approach for such merger. तो जो सेक्शन 233 है ऑफ द कंपनीज एक्ट 2013 प्रेस्क्राइब सिंप्लीफाइड प्रोसीजर फॉर मर्जर और अमलगामेशन ऑफ टू और मोर स्मॉल कंपनीज और बिटवीन ए होल्डिंग कंपनी एंड इट्स होल्डली ओन्ड सब्सिडियरी कंपनी और सच अदर क्लास और क्लासेस ऑफ कंपनी एज मे बी प्रेस्क्राइब्ड. So as for explanation to Rule 25 Sub-Rule 1(1)(a) of the Companies Rule 2021 Compromise Arrangement Amalgamation Amendment जो आया है, स्टार्टअप कंपनी में से प्राइवेट कंपनी इनकॉर्पोरेटेड अंडर द कंपनीज एक्ट 2013 और कंपनीज एक्ट 1956 एंड रिकॉग्नाइज्ड एज स्टार्टअप in accordance with the notification issued by DPIIT Ministry of Commerce and Industry. Further, a scheme of merger or amalgamation under Section 233 of the Act may be entered into between any of the following class of companies, namely two or more startup companies or one or more startup company with one or more small company. So yes, merger proposal can be carried out without the approval of the NCLT pursuant to the provision of Section 233 of the Act along with Rule 25 of the Companies Rule Car Rules. Okay, these companies can make application to the RD of the Ministry of Corporate Affairs, Government of India for fast track merger. The next question is, spin-off is one type of demerger wherein the shares of new entity is being distributed to the shareholders of the parent company on a pro rata basis. Explain in brief the reasons for spin-off. So in a spin-off में जो shares हैं of the new entity के वो distribute किए जाएंगे shareholders को of the parent company on a pro rata basis में. So there are two approaches in which spin-off may be conducted. In first approach, the company distribute all the shares of the new entity to its existing shareholders on a pro rata basis. This leads to the creation of two different companies holding the same proportion of equity as compared to the single company existing previously. The second approach is the flotation of a new entity with its equity being held by the parent company. So the parent company later sells the asset of the spun-off company to another company. In both the approaches, the parent company also retain ownership in the spin-off entity. A spin-off may occur for various reasons. Such reasons may include a company may conduct a spin-off so it can focus its resources and better manage the division that has more long-term potential. Then businesses wishing to streamline their operations often sell less productive or unrelated subsidiary as a spin-off. For example, a company might spin off one of its mature business unit that are experiencing little or no growth so it can focus on a product or service with higher growth prospects. A portion of the business is headed in a different direction and has different strategic priorities from the parent company. The company may adopt spin-off so it can unlock value as an independent operation. The downside of a spin-off is that their share price can be more volatile and can tend to underperform in weak market and outperform in strong market. Spin-off can also experience high selling activity and the share price may dip in the short term because of this selling activity even if the spin-off long-term prospects are positive. So next question है PQ Private Limited is under CIRP. The CIRP was initiated based on an application filed by the operational creator of PQ Private Limited. The resolution professional appointed by the NCLT is carrying out CIRP process has published advertisement for expression of interest. In the meantime, both PQ Private Limited and operational creator who has initiated the CIRP have arrived at settlement and would like to file withdrawal application. One of the other operational creator has contended that once the CIRP has commenced, an advertisement for EOI is given, that is expression of interest, the CIRP cannot be withdrawn. So referring the relevant case law and suitable provisions of the regulation, answer whether the contention of other operational creator is tenable बताइए. So as per section 12A of the IBC 2016 जो adjudicating authority है may allow the withdrawal of the application admitted under section 7 or section 9 or section 10 on an application made by the applicant with the approval of 90% voting share of the committee of creditor in such manner as may be specified. So regulation 30A 1B of the IBBI insolvency resolution process for the corporate person regulation 2016 also provide that application for withdrawal under section 12A of the code may be made to the adjudicating authority after the constitution of the committee by the applicant through the resolution professional subject to the applicant stating the reasons justifying withdrawal if the application for withdrawal made after the issue for expression of interest under regulation 36A. So in the matter of Brilliant Alloys Private Limited versus Mr. S. Rajagopal and ORS, Honorable Supreme Court held that regulation 30A of the IBBI regulation 2016 insolvency resolution process for corporate person has to be read subject to section 12A of the IBC 2016, which does not impose the condition that withdrawal application has to be filed before the invitation of expression of interest. Thus, the Apex Court upheld the withdrawal of CIRP even after the resolution professional issued invitation for expression of interest from resolution applicants to submit the resolution plan under regulation 36A of the IBBI regulation 2016. Insolvency resolution process for corporate person. A similar stand was taken by the Apex Court in the matter of Abhishek Singh versus Hutamaki PPL Limited. Hence, keeping in light the provisions of the IBC and regulations, the contention of other operational creditor are not tenable. So next question है, what are the order that can be issued by the debt recovery tribunal once the dues have been finalized to be paid? So if the DRT has issued a certificate of recovery against the company and such company is under liquidation, what orders can be issued by the DRT to recover the dues? बताइए. So where it is proved to the satisfaction of the debt recovery tribunal that the claim of the applicant has been adjusted wholly or in part by any lawful agreement or compromise in writing and signed by the parties, or where the defendant has repaid or agreed to repay the claim of the applicant, further the tribunal जो है may, after giving the applicant and the defendant an opportunity of being heard in respect of all the claims set off or counter claim if any, and interest on such claim within 30 days from the date of conclusion of the hearing, pass interim or final order as it deems fit, which may include order for payment of interest from the date on which payment of the amount is found due up to the date of realization or actual payment. So the tribunal, after it appear to be just and convenient, the tribunal may by order appoint a receiver of any property, remove a person from the possession or custody of the property, commit the case to the possession, custody or management of the receiver, confer upon the receiver all such power as the tribunal thinks fit, appoint a commissioner for preparation of inventory. So where a certificate of recovery is issued against the company as defined under the Companies Act 2013 and such companies under liquidation, the tribunal may by an order direct that the sale proceeds of the secured asset of such company be distributed in the same manner as provided in section 326 of the Companies Act 2013 or under any law for the time being in force. So next question है, whether NCLT or NCLAT has a right to interfere with the decision of the committee of creditor, discuss in view of some decided case law. बताएं. क्या बोला गया है, व्हाट आर द ऑर्डर जो कि इशू किया जाएगा डेट रिकवरी ट्रिब्यूनल के द्वारा वंस द ड्यूज हैव बीन फाइनलाइज्ड टू बी पेड. सो इफ द डीआरटी हैज इशूड ए सर्टिफिकेट ऑफ रिकवरी अगेंस्ट द कंपनी एंड सच कंपनी इज अंडर लिक्विडेशन में है, तो व्हाट ऑर्डर कैन बी इशूड बाय द डीआरटी टू रिकवर द ड्यूज, बताइए. So where it is proved to the satisfaction of the debt recovery tribunal that the claim of the applicant has been adjusted, okay, wholly or in part by any lawful agreement के जरिए or compromise in writing and signed by the parties, or where the defendant has repaid or agreed to repay the claim of the applicant. Further, the tribunal जो है may, after giving the applicant and the defendant an opportunity set off or counterclaim, if any, and interest on such claim within 30 days from the date of the conclusion of the hearing, pass interim or final order as it deems fit, okay, which may include order for payment of interest from the date on which the payment of amount is found due up to the date of realization or actual payment. So जो ट्रिब्यूनल है एनसीएलटी, आफ्टर इट अपीयर टू बी जस्ट एंड कन्वीनियंट, द ट्रिब्यूनल जो है मे बाय ऑर्डर अपॉइंट ए रिसीवर को ऑफ एनी प्रॉपर्टी का, remove a person from the possession or custody of the property से, commit the same to the possession, custody or management of the receiver, confer upon the receiver all such powers को as the tribunal thinks fit, appoint a commissioner को for the preparation of inventory. So where a certificate of recovery is issued against the company as defined under the Companies Act 2013 and such companies under liquidation में है, तो जो ट्रिब्यूनल है may by an order direct that जो sale proceeds of the secured asset का of such company be distributed in the same manner में as provided in section 326 of the Companies Act 2013 or under any other law for the time being in force. Okay. So whether NCLT or NCLAT has a right to interfere with the decision of the Committee of Creditor, discuss in view of some decided case law, बताओ. क्या आंसर है, जो IBC है 2016 has provided the Committee of Creditor with exclusive access to negotiations along with the ultimate authority to deal and finalize the business and commercial decisions. Thereby the Committee of Creditor is also ended with the mammoth responsibility of evaluating the resolution plans and thereafter voting and approving the best resolution plan. Commercial wisdom of the Committee of Creditor has been held to be sacrosanct by various judicial precedents के साथ. So in the case of Kalparaj Dharamsi and another versus Kotak Investment Advisor Limited, the apex court observed that the evaluation of the proposal to keep the entity as a going concern, including decisions about the sale of the business or units, restructuring of debts, etc., are required to be taken by the committee of the financial creditor. So the apex court further observed that it has been provided that the choice of the resolution to keep the entity as a going concern will be voted upon by the committee, and there are no constraints on the proposals that the resolution professional can present to the committee. So it was held that the NCLT and NCLAT cannot interfere with the commercial wisdom of the Committee of Creditor except within the limited scope under section 30 and 31 of the code. So it was further held that the commercial wisdom of the committee has been given paramount status without any judicial intervention for ensuring completion of the stated processes within the timeline prescribed by the court. So the court जो है further held that there is an intrinsic assumption that the financial creditor are fully informed about the viability of the corporate data and feasibility of the proposed resolution plan. So in another notable judgment, the Honorable Supreme Court in the matter of K. Sasidhar versus Indian Overseas Bank curtailed the jurisdiction of the NCLT by observing that the NCLT has no jurisdiction and authority to analyze or evaluate the commercial decision of the Committee of Creditor and to inquire into the business justness of the rejection of the resolution plan by the dissenting financial creditor. So the Honorable Supreme Court in M.K. Rajagopalan versus Dr. Periaswamy Palani Gounder had disregarded the technicality of non-compliance of non-publication of Form G and instead assigned primacy to the commercial wisdom of the Committee of Creditor. Hence, based on the above, जो NCLT and NCLAT do not have a right to interfere with the decision of the Committee of Creditor. So next question है, EF Limited was under CIRP and NCLT has approved the resolution plan submitted by XY Private Limited, who is totally unrelated to EF LLP or its partner. Prior to initiating of CIRP, the EFLLP has entered into commercial agreement with Q Limited to supply them the goods manufactured by EF for a particular period. But EFLLP did not supply as per the terms, and Q Limited suffered huge loss due to breach of contract by EFLLP. Now, after resolution and successful commencement of the business again by EFLLP, Q Limited would like to claim damages for breach of the contract. Referring relevant provisions, answer whether Q Limited can claim damage for the breach of contract. So, as per section 32A subsection 1 of the IBC, the liability of a corporate debtor जो है for an offence committed prior to the commencement of the CIRP shall cease, and the corporate debtor shall not be prosecuted for such offence के लिए from the date the resolution plan has been approved by the adjudicating authority under section 31 में. So, according to section 32A subsection 2 of the IBC, no action shall be taken against the property of the corporate debtor in relation to an offence committed prior to the commencement of CIRP of the corporate debtor, where such property is covered है under a resolution plan में approved by the adjudicating authority, if अगर जो resolution plan है results in change in the management or control of the corporate debtor to a person who was not a promoter नहीं था, or in the management में or control of the corporate debtor or a related party of such a person, or a person जो है with regard to whom the relevant investigating authority जो है has on the basis of material in its possession में reason to believe that he had abetted or conspired for the commission of the offence and has submitted or filed a report or a complaint to the relevant statutory authority को or court को. It is further to be noted that if a prosecution had been instituted during the CIRP में against such corporate debtor, it shall stand discharged from the date of approval of the resolution plan, subject to the requirements हो गया of this subsection having fulfilled. तो जो अपेक्स कोर्ट है इन द केस ऑफ घनश्याम मिश्रा एंड सन्स प्राइवेट लिमिटेड वर्सेस एडिलविस एसेट कंस्ट्रक्शन कंपनी लिमिटेड रिकंस्ट्रक्शन कंपनी लिमिटेड स्टेटेड दैट on the date of approval of the resolution plan by the adjudicating authority, all such claims which are not a part of the resolution plan shall stand extinguished, and no person will be entitled to initiate or continue any proceedings in respect to a claim which is not a part of the resolution plan. The legislative intent जो है behind this is to freeze all the claims so that the resolution applicant starts on a clean slate and is not flung without any surprise claims. Accordingly, जो Q Limited है cannot proceed against EF Limited LLP, whose management is totally changed due to approval of the resolution plan of XY Private Limited approved by the adjudicating authority. Hence, Q Limited cannot proceed against EF LLP or its present partner for the breach done prior to CIRP. So next question है, the resolution plan is not a sale or auction or recovery or liquidation but a resolution of the corporate debtor as a going concern. Referring relevant case law, highlight on the importance of the statement. बताइए. So in the matter of Binani Industries Limited versus Bank of Baroda, the National NCLAT NCLAT noticed the object of the IBC 2016 and laid down that the first order objective is resolution, the second order objective is maximization of the value of the asset of the corporate debtor, and the third order objective is promoting entrepreneurship, availability of credit, and balancing the interest of all the stakeholders. So the Honorable Appellate Tribunal also held that the Insolvency and Bankruptcy Code defined resolution plan as a plan for the insolvency resolution of the corporate debtor as a going concern and not as a sale or auction or recovery or liquidation. So the tribunal held that the resolution plan जो है is not an auction. Each resolution plan जो है has a different likelihood of turnaround depending on credibility and track record of the resolution applicant, and feasibility, viability of a resolution plan are not amenable to bidding or auction. So it requires application of mind by the financial creditor who understand the business well. So not recovery. Recovery is an individual effort है by creditor to recover its dues through a process that has debtor and creditor on opposite sides. So the Insolvency and Bankruptcy Code prohibit and discourage recovery. Not a liquidation. So the IBC जो है does not allow liquidation of a corporate debtor directly and permit liquidation only on failure of the resolution process. तो जो IBC है therefore does not allow liquidation of the corporate debtor directly. It allows liquidation only on failure of the CIRP. तो जो IBC है रेदर फैसिलिटेट एंड एनकरेज रेजोल्यूशन इन सेवरल वेज। तो जो IBC एम्स टू बैलेंस द इंटरेस्ट ऑफ ऑल द स्टेक होल्डर्स। सो नेक्स्ट क्वेश्चन है, योर कंपनी हैज़ रिसीव्ड रिकवरी नोटिस फ्रॉम ए क्रेडिटर से विथ होम रिसीवेबल ऑफ द कंपनी आर डिस्काउंटेड विद द CFO चीफ फाइनेंशियल ऑफिसर ऑफ योर कंपनी is of the view that this is not covered as a financial debt under the IBC 2016 में, as the receivables are sold on non-recourse basis, referring the relevant provisions, comment करो whether the contention of CFO is correct. So as per section 5 clause 8 of the IBC 2016, financial debt means a debt हो गया along with the interest, if any, which is disbursed against the consideration for the time value of money and include करता है money borrowed against the payment of interest, any amount raised by acceptance under any acceptance credit facility or its dematerialized equivalent, any amount raised pursuant to any note, purchase facility or the issue of bond, notes, debenture, loan stock or any similar instrument, the amount of any liability in respect of any lease or hire purchase contract which is deemed as a finance or capital lease under the Indian accounting standard or such other accounting standard as may be prescribed, receivables sold or discounted other than any receivable sold on non-recourse basis, any amount raised under any other transaction may including any forward sale or purchase agreement having the commercial effect of a borrowing. So in view of the definition, financial debt and as per the IBC, receivables discounted other than any receivables on non-recourse basis is only covered as financial debt. Hence, the contention of the CFO is not correct in the given case as the receivable are sold on non-recourse basis. So next question है, a bank has initiated insolvency proceedings against the personal guarantor for corporate debtor. In the list of assets of a personal guarantor, one of the asset is pension plan taken in the name of a spouse of the personal guarantor. So the insolvency professional has sorted your opinion as to whether the above pension plan can be included as asset of the personal guarantor. Clarify referring relevant provisions of the IBC 2016. So as per section 79 subsection 14 of the IBC, excluded जो asset है include करता है unencumbered tools हो गया, books हो गया, vehicle हो गया, other equipment हो गया as are necessary to the debtor or bankrupt for his personal use or for the purpose of its employment, business or vocation. Unencumbered furniture, household equipment and provision as are necessary for satisfying the basic domestic needs of the bankrupt and his immediate family. Any unencumbered personal ornaments of such value as may be prescribed of the debtor or his immediate family which cannot be parted with in accordance with the religious usage. Any unencumbered life insurance policy or pension plan taken in the name of the debtor or his immediate family, and an unencumbered single dwelling unit owned by the debtor of such value as may be prescribed. So as per the aforesaid provision of the IBC, the pension plan in the name of a spouse who is the immediate family of the personal guarantor falls within the list of excluded asset and hence the same cannot be included in the list of assets of the personal guarantor. So what are the general duties of a debtor under the fresh start process में under the IBC 2016 में बताइए. So as per section 88 of the IBC 2016 जो debtor has the following general duties होती है under the fresh start process में. पहला है make available to the resolution professional को all the information relating to his affairs and attend the meetings and comply with the request of the resolution professional in relation to the fresh start process. Inform करेगा resolution professional को as soon as reasonably possible of any material error or omission in relation to the information or documents supplied to the resolution professional को or any change in the financial circumstances may after the date of application where such change has an impact on the fresh start process. The next question है whether the former directors of the company on which the insolvency proceedings have been initiated are entitled to receive the copy of the resolution plan from the resolution professional. बताइए, comment करो. So as per section 24 subsection 3 clause B of the IBC 2016, जो resolution professional है shall give notice of each meeting of the committee of creditor to the members of the suspended board of director or the partner of the corporate person as the case may be. So as per the proviso of section 24 subsection 4, जो डायरेक्टर्स हैं रेफर टू इन सबसेक्शन 3 क्लॉज बी में अटेंड करेंगे मीटिंग को ऑफ द कमिटी ऑफ क्रेडिटर्स का बट शेल नॉट हैव एनी राइट टू वोट इन सच मीटिंग. So in the matter of Vijay Kumar Jain versus Standard Chartered Bank and other, An appeal was filed with the Supreme Court against the order rejecting the prayer of an erstwhile director for getting copy of the resolution plan from the resolution professional. Both the NCLT and NCLET ruled the appellant had no right to receive the resolution plan, and the resolution professional has contended that only the member of the Committee of Criteria are entitled to have resolution plan as per section 30 subsection 3 IBC read with regulation 39 subregulation 2 of the CIRP regulation. So the Supreme Court expressly rejected the argument based on relying on the notes on clauses of section 24 of the code and held that every participant is entitled to a notice of every meeting of the Committee of Criteria. Such notice of the meeting must contain an agenda of the meeting together with the copies of all the documents relevant for the matter to be discussed and the issues to be voted upon at the meeting by regulation 21 subregulation 3. Obviously, the resolution plan are the matters to be discussed at such meeting, and the erstwhile board of directors are participants who will discuss these issues. So it was held that members of the erstwhile board of directors, being vitally interested in the resolution plans that may be discussed at meetings of the Committee of Criteria, must be given a copy of such plan as a part of the documents that have to be furnished along with the notice of such Committee of Criteria meetings. So the judgment also clarified that the resolution professional can take an undertaking from the erstwhile director to maintain the confidentiality of the information. So next question क्या है? Ritu Housing Finance Company Limited initiated CIRP against its corporate debtor Raj Infrastructure Limited under section 7 of the IBC 2016. The NCLT dismissed the application as not maintainable. The reason given was that winding up proceedings have already been initiated by the High Court. Quoting any decided case law confirm whether the application under section 7 of the code is maintainable when winding up proceedings against the corporate debtor have already been initiated. So in the decided case of India Bulls Housing Finance Limited versus Sri Ram Urban Infrastructure Limited, जो winding up proceedings है against the corporate debtor had already been initiated by the Bombay High Court. Further, जो fresh application था for insolvency proceedings has been filed with the NCLT Mumbai bench के साथ, which in turn had dismissed the application को as the same was not maintainable in view of the fact that Honorable जो Bombay High Court है already initiated the winding up proceedings. तो जो corporate debtor है appealed before the NCLT, LAT and tribunal examined the judgments and opined that once a second stage, that is liquidation winding up proceedings, has already been initiated, जो क्वेश्चन है of reverting back to the first stage of CIRP or preparation of resolution plan जो है does not arise. So while arriving at its judgment, जो NCLET है relied on the case of Forex India Private Limited versus Edelweiss Asset Reconstruction Company Limited, wherein the tribunal जो है observed that if a corporate insolvency resolution has started or on failure, if the liquidation proceedings has been initiated against the corporate debtor, जो क्वेश्चन है of entertaining another application under section 7 में और section 9 against the same very corporate debtor जो है does not arise, as it is open to the financial creditor and the corporate debtor to make a claim before the insolvency resolution professional or the official liquidator. However, the matter went on appeal before the Honorable Supreme Court, which declared by its judgment that the proceedings under section 7 में 9 में of the code are independent proceedings and shall remain unaffected by the winding up proceedings of the Companies Act. Thus, based on the above judgment given by the Honorable Supreme Court, जो application filed किया गया by Ritu Housing Finance Company Limited under section 7 में of the IBC code case maintainable है. The next question है जो term default है under the SARFAESI Act में and IBC 2016 में are different है, and based upon the purpose of the act examine the statement by analyzing the definition under both the act. बताइए. So as per section 3 subsection 12 of the IBC 2016, जो term default है means non payment of debt हो गया when whole or any part or installment of the amount of debt has become due है and payable है and is not repaid by the debtor on the corporate debtor as the case may be. Further, जो SARFAESI Act है वो define करता है term default को as non payment of any debt or any other amount payable by the borrower to any secured creditor को consequent upon which the account of such borrower जो है is classified as non performing asset in the books of account of the secured creditor के, or non payment of any debt or any other amount payable by the borrower, okay, with respect to debt securities after notice of 90 days demanding payment of dues served upon such borrower by the debenture trustee or any other authority in whose favor security interest is created for the benefit of the holder of such debt securities. सो नेक्स्ट बोला गया है जो सारफेसी एक्ट है 2002 का हैज़ एम्पावर्ड द बैंक्स एंड फाइनेंशियल इंस्टीट्यूशन with vast power to enforce the securities charged to them, and the purpose of this act is to enable and empower the secured creditor to take possession of their securities and to deal with them without the intervention of the court. So one of the objective of the Sarfacy Act is to provide a mechanism for the banks and other financial institutions to recover the secured asset. So on the other hand, जो purpose है of the IBC 2016 का is to offer a market directed time bound mechanism to resolve the insolvency and run the corporate data as a going concern wherever possible or exit where required. So the IBC deals with the reorganization and insolvency resolution of the corporate data, partnership firm and even the individual. So the IBC also provide an exit mechanism for a corporate person that has not defaulted through a voluntary liquidation process. तो जो statement given in the question में is correct as the objectives of both acts are different and term default is required to be read with the purpose of both acts in the relevant context. So next question है जो committee of creditor है of a corporate debtor by passing a resolution with 55% of the voting share wants to remove Mr. B as a resolution professional after taking his consent in writing in advance. Please examine, keeping in view of the provisions of the IBC code, that whether the committee of creditor can remove the resolution professional by passing a resolution with 55% voting shares. तो क्या बोला गया एज पर सेक्शन 27 ऑफ द IBC 2016 वेयर एट एनी टाइम ड्यूरिंग द CIRP जो कमेटी है ऑफ क्रेडिटर इज ऑफ द ओपिनियन है दैट ए रेजोल्यूशन प्रोफेशनल अपॉइंटेड अंडर सेक्शन 22 में इज रिक्वायर्ड टू बी रिप्लेस्ड, इट में रिप्लेस हिम विद अनदर रेजोल्यूशन प्रोफेशनल के साथ इन द मैनर प्रोवाइडेड अंडर दिस सेक्शन में. तो जो कमेटी ऑफ क्रेडिटर है मे एट ए मीटिंग में बाय वोट ऑफ 66% ऑफ द वोटिंग शेयर रिजॉल्व टू रिप्लेस द रेजोल्यूशन प्रोफेशनल appointed under section 22 may with another resolution professional subject to a written consent from the proposed resolution professional in the specified form में. Then next बोला गया है जो committee of creditor है shall forward the name of the insolvency professional proposed by them to the adjudicating authority को. The adjudicating authority shall forward the name of the proposed resolution professional to the board को for its confirmation, and a resolution professional shall be appointed in the same manner as laid down in section 16. So where any disciplinary proceedings are pending against the proposed resolution professional under subsection 3 में जो resolution professional है appointed under section 22 shall continue till the appointment of another resolution professional under this section. Here approval of 66% voting share right shares of committee of creditor is required for replacing the resolution professional. So Mr. B cannot be removed as resolution professional with the committee of creditor passing resolution constituting 55% voting share. So next question है 6A1 discuss on the provisions of the management of the affairs of the corporate debtor during the pre-packed insolvency resolution. Also brief the powers of the committee of creditor investing the management of the corporate debtor in pre-packed insolvency resolution process में बताइए. So section 54H of the IBC 2016 provide following provisions with respect to management of the affairs of the corporate debtor during the pre-packed insolvency resolution process period. पहला है the management of the affairs of the corporate debtor shall continue to vest in the board of director or the partner as the case may be of the corporate debtor subject to such condition as may be specified. जो board of director है और the partner as the case may be of the corporate debtor shall make every endeavor to protect and preserve the value of the property of the corporate debtor and manage its operations as a going concern. And जो promoter है member personal partner as the case may be of the corporate debtor shall exercise and discharge their contractual or statutory rights and obligations को in relation to the corporate debtor subject to the provisions of this chapter and such other conditions and restrictions as may be prescribed. So section 54J of the IBC 2016 prescribe the following provisions in respect to the power of the committee of creditor investing the management of the corporate debtor with the resolution professional. So where the committee of creditor at any time during the pre-packed insolvency resolution process period by a vote of not less than 66% of the voting share is resolved to vest the management of the corporate data with a resolution professional. तो जो resolution professional है shall make an application for this purpose to the adjudicating authority को in such form and manner may as may be prescribed. So on an application made under subsection 1 में if the adjudicating authorities of the opinion है that during the pre-packed insolvency resolution process जो affairs हैं of the corporate debtor के have been conducted in a fraudulent manner or there has been gross mismanagement of the affairs of the corporate debtor, it shall pass an order vesting the management of the corporate debtor with the resolution professional के साथ. सो नेक्स्ट क्वेश्चन है जो ऑब्जेक्टिव है ऑफ द सारफेसी एक्ट एंड आईबीसी 2016 का आर ऑल टुगेदर डिफरेंट है, कैन नॉट बी इंटरचेंजेबल. एग्जामाइन करो स्टेटमेंट को हाईलाइटिंग द प्राइम ऑब्जेक्ट्स ऑफ बोथ द एक्ट. बताइए सो क्या बोला गया है. जो सारफेसी एक्ट है 2002 का हैज़ एम्पावर्ड द बैंक्स एंड फाइनेंशियल इंस्टीट्यूशंस को विद वास्ट पावर टू एनफोर्स द सिक्योरिटीज चार्ज टू देम एंड द पर्पज ऑफ दिस एक्ट इज टू अनेबल एंड एम्पावर द सिक्योर्ड क्रेडिटर को to take the possession of their securities and to deal with them without the intervention of the court. One of the objectives of the Sarfacy Act is to provide a mechanism for the banks and other financial institutions to recover the secured asset. On the other hand, जो purpose है of IBC 2016 का is to offer a market directed time bound mechanism to resolve insolvency and run the corporate data as a going concern wherever possible or exit where required. तो जो आईबीसी है डील विद द रीऑर्गेनाइजेशन एंड इंसॉल्वेंसी रिजोल्यूशन ऑफ द कॉर्पोरेट डेटा पार्टनरशिप फार्म एंड इवन द इंडिविजुअल. सो द आईबीसी ऑल्सो प्रोवाइड एन एग्जिट मैकेनिज्म फॉर ए कॉर्पोरेट पर्सन दैट हैज़ नॉट डिफॉल्टेड थ्रू ए वॉलंटरी लिक्विडेशन प्रोसेस. तो जो आईबीसी है ले डाउन करता है फॉलोइंग की ऑब्जेक्टिव्स को. क्या क्या है. तो पहला है टू कॉन्सोलिडेट एंड अमेंड द लॉ रिलेटिंग टू रीऑर्गेनाइजेशन एंड इंसॉल्वेंसी रिजोल्यूशन ऑफ द कॉर्पोरेट पर्सन पार्टनरशिप फार्म एंड इंडिविजुअल टू प्रोवाइड फॉर ए टाइम बाउंड इंसॉल्वेंसी रेजोल्यूशन मैकेनिज्म. दूसरा है टू एंश्योर मैक्सिमाइजेशन ऑफ द वैल्यू ऑफ द एसेट्स. तीसरा है टू प्रमोट एंटरप्रेन्योरशिप. चौथा है टू इंक्रीज द अवेलेबिलिटी ऑफ क्रेडिट. देन फिफ्थ है टू बैलेंस द इंटरेस्ट ऑफ ऑल द स्टेक होल्डर को इंक्लूडिंग अल्ट्रेशन इन द ऑर्डर ऑफ प्रायोरिटी में ऑफ द पेमेंट ऑफ द गवर्नमेंट ड्यूज. एंड टू एस्टेब्लिश किया जाएगा इन इंसॉल्वेंसी एंड बैंक्रप्सी बोर्ड ऑफ इंडिया को एज ए रेगुलेटर्स बॉडी to provide procedure for connected and incidental matter. Okay. So therefore जो statement है in the question में is correct in the light of the objectives of both the Sarfacy Act 2002 and the IBC 2016 which are altogether different and cannot be interchangeable. Okay. The next question है insolvency professional जो agencies हैं play a crucial role in regulating and educating the insolvency professionals. So elucidate the functions of the insolvency professional agency as enshrined in the code में. बताइए. सो एज पर सेक्शन 3 क्लॉज 20 ऑफ द आईबीसी 2016 जो इंसॉल्वेंसी प्रोफेशनल एजेंसी है मीन्स एनी पर्सन रजिस्टर्ड है विद द बोर्ड के साथ अंडर सेक्शन 201 में एज एन इंसॉल्वेंसी प्रोफेशनल एजेंसी. सो जो इंसॉल्वेंसी प्रोफेशनल एजेंसीज हैं वो डेजिग्नेटेड हैं टू रेगुलेट द इंसॉल्वेंसी प्रोफेशनल. सो दीज एजेंसीज जो हैं एनरोल करते हैं इंसॉल्वेंसी प्रोफेशनल को, प्रोवाइड प्री रजिस्ट्रेशन एजुकेशनल कोर्स to its enrolled जो members and enforce a code of conduct for their functioning. So they also issue authorization for assignment to the IP and insolvency professional enrolled with them. So क्या बोला गया in exercise of the power conferred by the IBC 2016 जो IBBI है Insolvency and Bankruptcy Board of India has framed the following regulations to regulate the working of the insolvency professional agencies. सो जो इंसॉल्वेंसी एंड बैंक्रप्सी बोर्ड ऑफ इंडिया रेगुलेशंस हैं 2016 का मॉडल बाई लॉज एंड गवर्निंग बोर्ड ऑफ द इंसॉल्वेंसी प्रोफेशनल एजेंसीज एंड आईबीबीआई रेगुलेशन 2016 दैट इज़ इंसॉल्वेंसी प्रोफेशनल एजेंसीज हो गया. देन उसके बाद है अकॉर्डिंग टू सेक्शन 204 ऑफ द कोड जो इंसॉल्वेंसी प्रोफेशनल एजेंसीज हैं परफॉर्म करते हैं फॉलोइंग फंक्शंस को, नेमली ग्रांट मेंबरशिप टू पर्सनस को हु फुलफिल ऑल द रिक्वायरमेंट सेट आउट इन द बाई लॉज में ऑन पेमेंट ऑफ मेंबरशिप फीस. दूसरा ले डाउन करेगा स्टैंडर्ड्स ऑफ प्रोफेशनल कंडक्ट फॉर इट्स मेंबर, मॉनिटर करता है परफॉर्मेंस को ऑफ इट्स मेंबर का, सेफगार्ड करेगा राइट्स को, प्रिविलेजेस को, इंटरेस्ट को ऑफ द इंसॉल्वेंसी प्रोफेशनल हु आर इट्स मेंबर, सस्पेंड करेगा कैंसिल करेगा मेंबरशिप को ऑफ द इंसॉल्वेंसी प्रोफेशनल हु आर इट्स मेंबर ऑन द ग्राउंड सेट आउट इन बाई लॉज में. देन रिड्रेस करेगा ग्रीवेंसेज ऑफ द कंज्यूमर को अगेंस्ट द इंसॉल्वेंसी प्रोफेशनल हु आर इट्स मेंबर एंड पब्लिश करता है इन्फॉर्मेशन को अबाउट इट्स फंक्शंस list of its member, performance of its member, and such other information as may be specified by the regulations.